Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. We've been talking estate planning this morning. We've got my good friend, special guest, Russ Cook with Russ Cook and Associates over in Brentwood, Tennessee. Russ and I have been working together for, as I said, somewhere between 15, 20 years now with clients. Done a lot of estate planning. Really like Russ's approach, and his documents are solid. And this is one of the things that if you've been a while since you've had your estate planning documents reviewed, I would highly recommend doing so. And to help with that, Russ is it's at $450 still, Russ?
400.
400. So normally for a consultation it's $400 with Russ, but he's gracious. He's going to come into our office to meet with you, and again, we can set up a conference call. We can do it that way if you feel more comfortable. But if you'd like to come in and do it that, we'll do a review. In either case, we'd get a copy of your documents. Russ will review those. He will give you review, well, basically an analysis, I guess, of those documents, tell you what the weaknesses may be or if everything is good. With all the new acts that have passed, in particular, if you look at the Secure Act that we've been talking about this morning that passed just in December of 19, if you've got retirement accounts that are going to be going to your children, and your plans were set in place before this, before 2020, then it's a good time to do a review and see what the different options may look like, these trade-offs that we've been discussing. So again, if you'd like to take advantage of getting a review of your documents as well as the comprehensive planning that we do, just call my office. The number is 615-376-5325. We got people standing by. They'll get your information, send you out a checklist of things to bring to your appointment with me. That would include, yes, if you want to do estate planning documents, those. Maybe you haven't done an estate plan. It's one of those biggest things that I think we all procrastinate about and put off, and I'll get to it, and now's like a good time. Let's make that round to it. Let's do it now. Let's get round to it. So 615-376-5325. You like the comprehensive plan, review of your estate planning, or to find out what your options are for an estate plan. All of that we'll do for you. And when we do a comprehensive planning, by the way, we answer questions with regard to Social Security, Medicare. We get into tax planning with you. Of course, the estate planning we've been talking about, long-term care needs. We cover how you can do that. Most of my clients are able to self-insure for that because there's the way we structure their plans. I can help share that with you as well. Lots of strategies, lots of ways that we can help you. Again, just call the number 615-376-5325. When you call, we'll have someone get back to you, give you a checklist of things to bring to your appointment with me. And when you come in to see me, or if we do it by phone, we'll get you a free copy of my book, 7 Steps to Financial Freedom in Retirement. And guess what the seventh step is? That's right. Step 7, Chapter 7 is estate planning. And Russ, we talk about, I'm going to we'll come back to the Secure Act here in a moment, but just we call the foundation that you set up for a plan, because you come in when you're meeting with someone and they're, depending on what their needs are, we start with this foundational, the five documents that make up the foundation of a good estate plan, being a revocable. Well, in fact, let me let you jump in there. What would those 5 documents be?
There would be a will, power of attorney for health care, living will, and for those that want to avoid probate, the revocable living trust. I like the revocable living trust as an option as opposed to just using a will to distribute your assets, especially when you have retirement accounts that you want to make sure go in trust for your kids, because the revocable living trust starts when you sign it, meaning it doesn't require a court-approved process in order for it to be considered valid. So whenever a person passes and we need to ship documents off to an IRA custodian to prove that there is a trust that's created for the kids, we can do that rather immediately than having to wait to probate a will that would then have to be sent after probated. So again, you want the most flexibility. You want to make sure that these documents are part of your estate planning package and that they're up to date.
And this is one of those areas when we get into, we talk about a revocable living trust, but a revocable living trust can also have different looks to it. For instance, the brains doing a little freeze here. What's the trust that we've been talking about? The
The
Community property. Thank you.
trust.
I'll get
Yes.
there. Right. I'm slow this morning. More coffee, please. So community property trust is an example. So there are different types of revocable living trusts. What makes a community property revocable living trust maybe more advantageous for some than one without those provisions?
Well, it's pretty much the go-to document if you're a married couple and you have capital gain assets. The reason that this trust is so useful is it allows us to get a full step up in cost basis on those assets that are in the trust. So to give you just kind of a perspective of what that means, let's say that you and your wife buy, or husband buy an investment through Hank in a mutual fund that was worth $10 when you bought it. You each own it jointly, so there's a 50-50 ownership interest there. When let's say the first spouse dies, the mutual fund is now worth $20. Well, the decedent's half, that is their initial cost basis, which is $5, gets bumped up to $10 according to the federal law. However, the survivor's half does not. So if the surviving spouse decides to sell that same mutual fund after the first spouse dies, they're going to end up paying capital gains taxes on their share of it. The community property trust allows for a husband and wife to fund the trust with the assets like this mutual fund, or buy assets through it like this mutual fund. And even though the husband and wife own a 50-50 interest in the assets in the trust, when the first spouse dies, not only does the decedent's half get bumped up, cost basis bump up, but also the survivors. So what that would mean is, with this mutual fund, if it's worth $10 when it's purchased, $20 at the time of the first spouse's death, the new cost basis, that's the number that you use to determine capital gains taxes, is now at the same number as the current value. So if it's sold, there is no capital gains tax. It's a huge win for our clients that live here in Tennessee.
This is one, so that goes not, for investments like stocks, mutual funds, stock mutual funds, but also for real estate, of course. Mm-hmm. And I know we've had great success with clients that have, have rental properties that they have depreciated over many years, and this can be a real boon to the survivor of the two, for the couple. And of course, step up in basis is excellent for the children as well when assets are passing to them, getting an additional step up to where they're not going to have to pay any capital gains tax. I met with a client, Russ, earlier this week, and unfortunately, he and his mom had transferred the asset to him at the time, like some years ago. Now, mom just recently passed. So the plus side is it's joint ownership, so it passed to him pretty easily. The downside is, of course, he's got a capital gains tax now. Yeah,
and that's one thing that people are not kind of understanding, or at least they're not aware of it, really, is when they pass assets from a parent to a child while both the parent and the child are living, or they have a joint account that passes to the child, they're losing out on this benefit that we have, this step up in cost basis. And it may be one of those benefits that ends up going away depending on who gets elected in the fall. So there's no reason for us not to plan for it. It is that valuable.
Yeah. Mm-hmm. So this is one of the things when it comes to planning and setting up your estate plan, a big part of your overall planning, right? We want to first take care of all the things that are going to occur during your lifetime. That's the purpose of getting your planning in place. And then the second thing we're looking at is what happens. So it's basically, what do I want to have happen to my stuff while I'm living, and what do I want to have happen when I'm gone? And one of those areas that can get into in between, of course, are these long-term care needs. What happens if I become incapacitated? So an example might be for if you're married and one becomes incapacitated, maybe the other spouse is taking care of you, but being able to access retirement accounts and do other things on your behalf. In particular, if, let's say, God forbid, it's a stroke and you're not able to communicate things or act on your own, this is where needing to empower your spouse, good estate plan starts there. So, Russ, what would you recommend for someone to make sure during their lifetime that they've got these same protections?
Well, you would want the ancillary documents documents that I mentioned are also part of the 5 essential documents of a good estate plan. That is the power of attorney for financial matters, the power of attorney for healthcare matters, and the living will. And these are documents that allow you to appoint an agent to represent you both in your financial affairs, which if you have IRAs, 401ks, or any other accounts where you need someone to make sure those accounts are drawn from, you're taking your RMDs, everything else during your lifetime, if you're unable to do that for yourself. And the healthcare power of attorney is allowing someone to make healthcare decisions for you in the event you cannot. And then the living will. There are many situations that we run into where people are calling us after the fact. They never got these documents prepared, and someone's ended up in the hospital or is maybe become incompetent and can no longer handle their own affairs, and they're unfortunately being forced to go to court to get someone appointed a conservator in order to make these decisions for them. Very expensive, very time consuming, and very gut wrenching, because then you got to bring the person who you're trying to get conservatorship over into court. Not a good scene. These documents take care of all of that.
Excellent. And this is one of those areas too. So now, let's say we go to the next scenario. So that's why it's so important for husband and wife for you to have this kind of handled, or for anybody, even if you're single. This is to pick that person that you want to handle your affairs for you and get that in, down in writing so that it's going to be legally effective, as opposed to having to go to court, as Russ was just saying, to get it done that way. The next piece is, now let's say you're the survivor, again, single, whichever it might be, and you become incapacitated, right? This again, where these documents come in, Russ, is how about the administration of trust assets versus those assets outside of the trust when someone becomes incapacitated?
Yeah, if you have assets single and you want someone to manage those assets for you, if you do become incapacitated, a lot of times we're advising clients to set up their estate plan using a revocable living trust. For whatever reason, if you have someone that's there to be a successor trustee when you cannot serve, the banks are much more receptive to that sort of arrangement, allowing someone to come in and take care of those accounts for you. You can still do it through a power of attorney, but there are more hoops that you normally have to jump through with a bank. So again, we're trying to give our clients all the necessary documents to take care of any situation that we can foresee. And we like the revocable living trust during a client's lifetime because it allows for that smoother transition of assets in the event someone does become incompetent or in the event that they pass away. And one other point that I think people miss, they might think, well, I don't need these documents till I get older or whatever. That's not true. We've had clients who have children, let's say, adult children, young, who have traveled abroad, gotten an accident, and then they don't have these documents in place, and they're dealing with foreign countries and foreign hospitals, and they don't understand who has control over what. And in the cases where something like that happened to a child of our client, where we did the documents, the child actually signed a power attorney for healthcare and living will, appointing his parents as his agent, we were able to send those documents overseas or wherever the person was hurt to the hospital, and there was no question about who had control over that child's affairs. Because remember, when a child turns 18, they got friends, they got girlfriends, they got all these other people in their life. Who's going to be making those decisions for them?
Yeah, that's an excellent point. This is one of those areas about good planning. We talk about all the time, right? Failing to plan is planning to fail. We want to get these things done now, because once an event happens, as Russ had given a number of illustrations for, that's, it's kind of late then. Now you're going to have to involve courts. It's going to be a lot more expensive. It's going to be a lot more time consuming, and he said a lot more gut wrenching as well, and having to deal with it. You can have all that handled up front and have the peace of mind knowing that you're in good shape. All right, we've got more to go over with your estate planning, but first a break. Join us here. We'll be right back on the Retirement Report.